Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly, every other Thursday telephone call, which we hold for the community. You would have heard the disclaimers that were stated when you logged in. All those stay in place. With that said, as usual, I will first answer the questions that are marked, I believe, to be frequently asked questions, take up any follow-up questions you have on those, and then move along to the non-frequently asked questions. And at the end of it, time remaining out of the 1 hour we have, I will be happy to answer any questions from folks who were not able to post for the conference. Just let me make sure that you can hear me okay.
The conference is now in conversation mode.
Can you guys hear me all right? Hello? Can you hear me okay?
Yes, Rajiv, we can.
Thank you. Thank you. Okay.
The conference is now in presentation mode.
So the first question is sort of kind of interesting because it was being discussed just a couple of weeks ago amongst some lawyers that I know. We were talking about what is the impact of violating the immigration laws of other countries, not US, but other countries on the United States immigration. So Ranjit Singh has a question. He says, I became a US citizen. I'm going to apply for my parents, but they have violated or potentially violated some terms of UK immigration laws. They had applied for asylum, then they went back, etc., etc., and there is no criminal activity, there's no objection. So the question is it going to affect the permanent residency in the USA? And the answer is no, it should not. The reason we were discussing it came up because, if I remember correctly, the government is proposing a new version of the form I-485. The form I-485 is the form that you use to apply for adjustment of status, the last step in the green card process if you are in the United States. In the new version of the I-485, they actually have questions about violating immigration laws of other countries. In my view, it shouldn't matter. I don't think that makes any difference. Remember only that, and this is a question Ranjit has also asked, is it better to file from USA or from India? My answer to that is, I do not see how breaking UK immigration laws should impact their US immigration. Government would like us to be responsible for obeying every law of every country, but as long as it's not a criminal violation, I do not see how this has any bearing. So in my view, the answer is no effect. There is a part of the question though, should we do green card outside the United States for them, or should we do adjustment of status? And the answer to that is, adjustment of status in the ultimate analysis is still a discretionary remedy. So let's say I have a violation of some kind. Let's say I was out of status in the United States for a certain number of days. They can deny me adjustment of status, but they cannot deny me consular processing. So between consular processing and adjustment of status, government has less discretion in consular processing. Given the circumstances of your case, Mr. Singh, I would go ahead and file for them here. There are other issues in applying from the United States. Make sure there's no violation of the immigrant, non-immigrant intent. We've discussed that several times in the past. If you go over our frequently asked questions, other people have asked this question. What if my parents are here on a tourist visa? Is it okay to apply for a green card? Go over the frequently asked questions, and of course, you're welcome to call back if you should have any further follow-ups. *5 on your phone if you have any follow-up questions or related question to this topic that I just discussed. Press *5 on your phone. Just remember that *5, that's always your key to raising your hand so I can then unmute you and converse with you. Next question is also a frequently asked question that I have actually discussed several times, but I don't mind discussing it again because it does keep coming up. So the question relates to the general area where you are trying to get birth certificates for people who are going through the immigration process, whether it's your parents, your siblings, or even your children. What if the birth certificates are not available? How do you deal with those situations? So in this case, what has happened is they applied for 130 for father to get his green card through consular processing. They are a US citizen. That's Chris actually. Chris is a US citizen. They need only the US citizen's birth certificate and not the parent's birth certificate. So they don't understand why is there an RFE for the parent's birth certificate, and that's normal. That's usually also required. And as Chris mentions, these documents are not available for people born prior to 1968. Should I still provide a certificate of non-availability? If you can easily get it, Chris, get it. But we have had cases where instead of providing a certificate of non-availability, we have provided a copy of the reciprocity table of documents saying that birth certificates are not available for this country for people born before 1968. So the answer is get it if you can, but if it's too cumbersome, you could try to set up the reciprocity table as evidence that such documents are not available. The reason I prefer to get the certificate of non-availability is that there's a difference between non-availability of birth registration and discretionary or matter of choice registration. So as I recall, before 1968, at least in India, it used to be that you could register the birth if you wanted to, but you did not have to. So therefore, it becomes important to demonstrate that there in fact was no registration of this birth. Last question is about the affidavit from close relatives. What does the affidavit need to show? And I can't give you the exact language. I'm sure we have some samples in our frequently asked questions. Typically, what I do is, if you remember, and I don't know if you've seen this, but the law only says that a relative who gives an affidavit of your birth should be alive when you were born. So let's say you're giving your father's affidavit of birth and your uncle is giving it. Uncle should say that I hereby certify that to the best of my knowledge, information, and belief, father, whatever the full name is, was born on dash 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 date, period, when I was born in dash 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 year, so I was alive when he was born. They don't have to testify beyond that. You can add a line there saying that because you already said to the best of my information, knowledge, information, and belief, I think that covers everything. So that is the way I would do it. If you have a follow-up question on this, Chris, go ahead and press *5. I'm going to go on to somebody else had posted, Tanya had posted similar questions, so I'm going to get into those now. I recently became a US citizen. This is a continuation of the same theme. I recently became a US citizen, planning to sponsor my mother's green card, currently on USA on a travel visa. She's leaving. I don't want her to leave because of the coronavirus situation. So for you also, Tanya, make sure you review the frequently asked questions we have on immigration.com that talk about applying for a green card while somebody is here on a tourist visa. It's not okay to enter the United States with a preconceived intention to convert to green card, but it's okay to change your mind after you've been here a few months. Why? Because if you come in with a preconceived intention that you're going to convert to green card, then you are misusing your tourist visa. That can be fraud, and fraud is a permanent bar. I have a case, I mentioned this last time, out of New York, where two parents got stuck with this issue, and now they are struggling because the government has put a permanent bar against their entry into the United States, far less giving them a green card. They are saying you cannot ever come back. And they were asking me to file a lawsuit against the government in Washington, D.C. In some cases, it's not a good idea to file in Washington, D.C. because the case might get transferred back to New York. So I told them, I said, look, I don't mind doing it, but chances are this case is going to get transferred back to New York. So why hire a lawyer in Washington, D.C. to fight a case in New York where we are not even admitted? Washington, D.C. is great for many, many cases, especially where you're challenging a policy. If there is a policy you are challenging, it's okay to sue the government in Washington, D.C. So therefore, be careful you don't run afoul of that problem. Okay? She talks about the birth certificate. I'm planning to apply for green card for my mother, but her last name on my birth certificate is different than her birth certificate, marriage certificate, and passport. Birth certificate has her married last name. That's okay. The fact that she has maiden name in some places and married in some others, that's easy enough. What additional document? Just give a statement from her that I certify that my married name was this. I took my husband's name, and before that I had my maiden name, which is this. And that should be good enough. In order to avoid travel during Corona time, I want to extend her travel visa. I would want you to, it's okay to extend it, especially during this time. For other people who are extending, just make sure after you extend, your parents don't come back for at least a year. Otherwise, the government can claim that, oh, you've been living here in USA and visiting your home country. So I think travel visa, extension of your tourist visa at this point is okay. Just remember one thing. If you are planning to apply for her green card, it should be said so. I do not like to conceal anything from the government. If I were filing for an extension, I would say, I want an extension. Oh, by the way, we are thinking or considering filing a green card for her also. By the time they make a decision, I would have filed the green card. I don't really care what they do with my tourist visa. Okay. Is it okay to, this is good that she's been traveling here so many times. That's a good, because if she travels and goes back, that's a good indication of her desire not to violate any immigration laws. Okay. So once you file her green card, she can continue to stay here, even if the tourist visa extension is denied. So, and by the way, Tanya, one more thing that you may not know. The law is that parents, immediate relatives of US citizens, parents, children, etc., even if they have been illegal in the USA for 20 years, technically if they step outside, they can't come back for 10 years. But if you apply for their green card, they entered USA legally to begin with, and you apply for their green card with an adjustment of status, the fact that they were out of status or unlawfully present has absolutely no issue. So therefore, I'm not that concerned about getting an extension of their tourist visa. File an application. I think it's a good idea. But even though the application is pending, you can apply for their adjustment of status. And if the tourist visa is denied, tourist status is denied, we don't really care because they are parents of US citizens. Okay. So it's relatively straightforward. And I don't see why you should apply for a green card first and then apply for a travel visa or vice versa. That's your choice. If you apply for a green card within the life of the current tourist status, you don't need to apply for an extension. Filing an I-485, which is adjustment of status, is good enough. Okay. *5 on your telephone. If you have a follow-up question, press *5. Okay. Oh, there is one question. Let's see. Area code 443. Where are you calling from? Area code 443.
My name is Tanya. I'm calling from Baltimore.
Yes, ma'am. Tanya, you're not my friend, Tanya. Are you the same Tanya that I'm thinking of? Or are you a different Tanya?
I'm new to this forum.
Okay. Because I have a friend with that name in Baltimore. She's a Canadian citizen.
Oh, okay. Oh, okay. Yeah. Thank you, Rajiv, for answering so detailedly. I appreciate all your efforts.
Mm-hmm.
So the follow-up question I had was, with the current situation, I wasn't sure the green card processing time it's taking. So that's why my last question was, should I file the green card first and then the travel visa?
I don't really
Mm.
care, because once you have filed her green card, she's legal to stay in the United States. Okay.
Okay.
So what I would do
She's legal to stay.
yes, what I would do
Go
is,
ahead.
if it were my mom, I would make sure that there were no indications of her staying in the United States and having preconceived the idea of applying for a green card before she entered. What are the indicators of that? One, if she travels with her birth certificate, marriage certificate, etc. Two, she enters, I don't know if that's possible, but if she enters with a one-way ticket. Okay.
Okay.
Three, if she has sold off all her property or given up her lease if she's renting in her home country. These are some of the indicators that the person wants to stay in the USA permanently. In that case, using a tourist visa as a pretext to then apply for a green card becomes a problem. Although, another interesting thing is, and that's the issue I raised in the New York case, and we told the government that there is actually a presumption, even your own standard operating procedures say that we don't really hold the immediate relatives of US citizens to this standard. We let it slide. Even if they have a preconceived intent, we let it slide. Okay. But why take a chance with the Trump administration? They don't know their own mind. What are they going to apply any laws? So I would rather that make sure she doesn't have any indications of having a preconceived intention. Another important thing to remember is never apply for their green card or even start preparing the application until they have been here at least 90 days. I would say 4 months. Okay.
Yeah, it's exactly past 4 months now, so
you're good to go. Good to go. Apply for her, and once it's applied for, I-130 and 485 both, she has no issue continuing to stay here even if her tourist status expires.
Okay. And the indicators you were talking about, should I be submitting some sort of evidence of her?
No. Don't do it preemptively. Don't build the case of the opposition. Let them come back and say, that we want to get this information. At that point, I would want you to consult with a lawyer just to make sure you're doing it right. But filing the application itself, I'm not sure you need a lawyer for that. Okay?
Okay. Thank you so much.
You're
I
welcome.
appreciate your detailed answer.
You're very welcome. Good luck.
Thank you.
Okay, so we have no other questions on this. Let's go on to the next frequently asked question. Well, this is another one. This is a weird one, and I've always had a problem with this. H4 and H1 are both pending. What if the H4 gets approved first and the H1 later? What if the H1 gets approved and the H4 later? Government proposes something called the last action rule, which means whatever is the last action we take on your cases, that's the one that holds true. So if you have an H1 pending and an H4 pending, if we approve the H4 last, H1 first and H4 last, then you are on H4. If we approve the H1 last or most recently, then you are on H1. I personally don't think, and I've had the discussion with some of the very senior lawyers within the USCIS, we have been scratching our head saying, where did this rule ever come from? Because really there is no reason for this rule. Okay. Now with that understood, that there really is a questionable logic behind the last action rule, and I can explain that further if necessary, and hope if I get to do it in a court, I can explain it well. But in this case, rather than fight the government, we can try to see what works out best. I always tell people, I am not a law school professor. My job is not to find the theory of the law, but to find the best practical applications. So here you have an H1 and H4 pending. Obviously, whenever you are in a situation like that, you should consider, and you may need to talk with a lawyer because there could be implications. You should consider immediately withdrawing the application, number 2 application, if the number 1 approved is the one that you want. Okay, so let's take a look at Pravan's questions. Wife's H4 and EAD are valid till July 31st. We filed an extension, H4 and H4 EAD. The application support centers are still closed, so the process is stalled because of no biometric appointment. Now, didn't the government say that they are going to use the biometrics, the old biometrics for people in this situation? I think they did. So you can confirm that, but I'm pretty sure they're going to use the old biometrics. On the other hand, her employer filed for her H-1B, got picked up in fiscal year 2021 cap quota. Now they have premiumed it. We haven't got the receipt notice yet. So here's what I would do if I were you. As soon as the H1 is approved, I would withdraw the H4 EAD. I don't see any sense of leaving it out there. But you're right. If H1B gets approved before October 1st, then she'll be considered out of status for the period of July 31st to September 30th. Good point. I didn't think of that. What you should do is, that's why when we have complicated questions, I usually have one or two people more from the team in our office, because it's always possible to miss an issue. So you're right. Potentially they could raise that issue, although they don't. Normally they don't as a matter of practice, because it does happen all the time. But they could. See, once they approve the H1 with status, they normally don't make this issue again. But let's say they do. Okay. What you could do is, you could always send a request to the government saying that this should be H4 EAD should be considered withdrawn effective October 1st. Okay. Is this questionable? Yeah, I think it is. Between the choices of several gray areas, this is one way to do it. Not the only way to do it. Okay. So my concern sort of mirrors some of what you are thinking, that even though we don't really know the implications of this last action rule, whether it really exists or not. Okay. Another thing you could do, I'm trying to think of a practical solution to these issues. You can try another interesting experiment, and that's something I would recommend. What you can do is you can call the USCIS. It may be difficult to get through to a live human being, but you can try. And when you have an issue like this, they will put you in touch with a second-tier officer who is actually a USCIS officer. Ask them what they suggest. Okay. My guess is they are going to suggest that withdraw the H4. If the H1 is approved with an I-94, you should be fine. That would be my guess. But if they say, wait until the very last moment to withdraw the H4, I would still think you're okay. Why? Think about this. Think about the sequence of events. You have applied for an H4 extension. That's the extension of the life of the H4. That would be my argument if I were to take it to court. So we are extending the life of a visa or a status. That's one continuous stream. In the meantime, we have put in another right-angled stream or right-angled obstruction in the stream. We say, convert me to H1. Once you have converted me to H1, you cannot really extend my H4 anymore. So that application has become defunct by definition, because that stream was interrupted the moment my H1 was approved. Therefore, that application became meaningless. If you want to add meaning to that application, you should make me file an amendment asking for a conversion from H1 to H4. See, the stream of H4 was going. It got interrupted by a conversion to H1. So therefore, that stream cannot continue. The pending application has no meaning. That would be my argument. My practical suggestion, call USCIS. Get them to tell you what they say. Number two, call your local congressman's office or have your employer call them and see if they can find out the answer from the USCIS. Usually, they can get you good information, and I would definitely do both of them. If you find a conflict in the two answers, go ahead and get back on the conference with us. Okay? *5 if you have a follow-up question on this. *5. Okay, let's go on to the next frequently asked question. This is another one that has come up many times. I've discussed this many times. You will find it time and time in our frequently asked questions. Nothing much has changed on this in the last 10-15 years. My answer is still the same. First of all, in this case, you are leaving 7 months after you got your green card. I don't see any problem with that. If you want to change your employer, if you want to start your own business, if you want to take some time off, make sure it's less than 6 months. Don't go outside USA for more than 6 months. It's just easier. Okay? So after you get a green card, if you want to leave and you want to be out for less than 6 months, it's okay to do that. And there's no need to get into any kind of debate about this. This is simple enough. So if you quit your job and go back to your home country for a few months, less than 6, I don't see any problem. And when you come back and you find another job, negotiate a later start date, then quit and go back, that's okay too. You want to come back and work for yourself, that's okay too. None of them are these things, Asma, I think are a problem. So you could go any of these ways. And my opinion is only strengthened further by the law called American Competitiveness in the 21st Century Act, what we call AC-21. AC-21 allows you to change jobs even when the green card is pending. So therefore, I am not concerned about this situation at all, not even a little bit. *5 if you have a follow-up question. *5. What if you quit the next day after you got your green card? I think that's okay too. As long as as on the date you filed your 485, you had no intention to quit at a time certain, you would be okay. That would be my interpretation. And I've had some vindication of this type of situation in courts. Not exactly the same, but somewhat similar. Okay, no questions. Let's go on to the next frequently asked questions. This one also comes up very frequently. I've discussed it many times. So let's say I am running out of my 60-day grace period. I was on H1 or L1 or TN, any one of those visas. I'm running out of my 60-day grace period. And just to maintain my status, I apply for B1, B2 or B1 status. My 60 days have expired. I am waiting 2 months and all of a sudden an employer comes and files my H1B. What happens? Well, first of all, you cannot start working until the H1 is actually approved. Maybe lesser of an issue because now we have premium processing available, but nevertheless, you cannot start working until the H1 is approved. Second thing, unless this is the current thinking of the government and I'm hoping to change it. On the date they decide your H1, which was filed when your initial status had expired, 60 days had expired, and there's only B2 pending. If on the date they decide the H1, your B1, B2 is not already decided in your favor, under the current thinking, they will approve the H1 but make you go outside for a visa stamping. Why? Because pending B1, B2 is not status, it's merely authorized period of stay. And there's a difference in them. I personally think it's a bunch of baloney and it shouldn't affect people in that situation. We've tested this once in the court this year. The government very graciously accepted that they would let us get our H1 status, but that was a very specific type of case where there was some error on the part of the government as well. We are testing it again. We're filing a lawsuit this week. And in this one, what is happening is that there is one H1 pending, extension pending, employee changed jobs, and the second H1, let me rephrase that. The employee filed an H1 and changed job, but the job change was done after the original H1 had expired, but the extension was pending. So the government refused to give me an H1 because I filed the H1 after the 60 days were over. And we had told the client that's a possibility. After the 60 days, the 60 days were over, plus the fact that the original status had expired. So government came back as predictably and said, well, we're going to give you the H1 and you have to go outside for visa stamping. So we filed a lawsuit, or we are filing a lawsuit this week, which says as follows. If you look at the regulation says, we will not give you an H1 within USA if the previous case is denied. But the regulation doesn't say anything if the previous case is still pending. So if the previous case is still pending, you've got to give me status because your regulation, the plain words, plain English says so. Okay. So if that flies, maybe we can get the government to soften their stance on some of these pending B2 to H1 conversions. Because if you go outside USA, then you can't come back before December. Hopefully by that time, Trump has lost elections and the H1 statuses have been restored and the proclamation is gone. But unless that happens, you would have to work from outside USA. You will not be able to come back. So there's definitely grounds for testing that in courts if necessary. But current thinking, unless the B1, B2 is approved on the date they decide your second H1B, they are going to make you go outside USA. You have to apply for an H1 within the 60-day grace period if you want to start working right away, and you want to get your H1 within the United States. *5 if you have a follow-up question. And yes, premium processing is always advisable in these cases. This is from area code 347. 347, where are you calling from?
Yeah, Rajiv, this is New York. I'm calling from here.
Okay, go ahead, sir. I can hear you.
Yeah. The thing is, actually, I have an employer. He made me work for 7 days, but now he is telling that he will file a H1 for me, but and he will wait for the approvals. But even after the approvals, he will see if he has the project work or not. Otherwise, whenever his project starts, then only I can start.
You have a very complicated situation.
So I don't know how.
You have a very complicated situation because you worked for 7 days. And that is a violation of your status. So if you work without getting paid, everything that we can do for you is out the window. There isn't much we can do for you. Okay. That means you're having to go outside USA for visa stamping is inevitable. You can try. You can explain to the government what happened. You can even file a complaint against this employer, stating their misrepresentation, etc. But I think this is a problematic issue. You should not have worked. Okay. So unless you're willing to go outside USA, I would say fighting this case, I don't know. I don't think there's much here you can do. Okay.
Okay. So in this case, I mean, in such cases, even if we have applied for B2 and H1 is pending, and if H1 is approved, we have to go back. I mean, they will not change the status here.
Let me take you a step back. Your last day worked was April 7th, and you were paid up to April 22nd. So April to May, May to June. Your 60 days are already over. They have not applied for an H1, so you will not be covered by any exception under which you could work. The 7 days of work because unauthorized employment. Because of that, even B1, B2 is not going to work for you unless the government chooses to forgive you for 1 week. They may not do that. This government is not.
They made me work.
Go ahead.
Actually, they made me work, but they have not paid me.
In that case, I think you're okay. The fact should be revealed to the government nonetheless that I did work for 7 days, but make it clear that I was not paid for that time, and I'm told by my lawyers that is not considered to be employment. Okay, because in my view, and I think most lawyers would agree with me, employment has 2 elements. One is work and the other one is compensation. The compensation can be in cash or in kind, but it has to be some compensation. And by the way, for a for-profit employer to take free work from an employee is a violation of Fair Labor Standards Act. So they are in violation of other labor laws as well. So in your case, I would apply for a B2. You said you have not yet applied for a B2 yet, right?
No, I applied on 6/22.
Okay, so you applied
was,
before, right?
almost,
No, I just saw that. So you applied on 6/22. Was that within 60 days of when you stopped working? No.
no, this was 60 days from my last payday.
Okay. So actually the paychecks tell you which period they cover, right? Does the
Yes,
paycheck say it
because
covers
I was
you?
paid for 10 days.
Okay. Okay.
Yeah.
Okay. Well, I think I can certainly hope that the government will accept the fact that you filed within 60 days of when you stopped working. But I always advise people to be safe and consider 60 days from the date you stopped working. Okay. Now,
Okay.
one of the things I would do if I were you to be very, very cautious. Although I don't think that's an issue in your case yet, you could count 180 days from April 7th and plan on leaving the USA if your situation has not been regularized.
Okay.
Okay. Although unlawful presence doesn't begin until your I-94 expires. But assuming that your employer would have gone and revoked your H1, I just think it gets very messy. I would plan on leaving within 180 days of April 7th.
Okay. To be on the safer side.
Just to be on the safe side. That brings you pretty much to October. Okay.
Okay.
Anything else I can help you with?
Yeah, just one thing. So even if I get employment now, you mean the H1 will be consular processing?
Hang on.
In any case?
No. I never advise that. When people tell me I'm applying for consular processing, I said that's like giving up the fight without ever fighting it. So,
no.
Hang on.
Will they consider a consular process?
Let me finish.
You can go file a premium.
Let me finish. Give me 1 minute to finish my thought, and then you can ask me a question if you have one. See, when you apply for an H1, you have two choices. You will say, give me my status within the USA, or I'll go outside USA for visa stamping, what you call consular processing, right? So you have a choice of extension of status or extension of stay or consular processing. If you apply for consular processing, you've not even fought, because that's the worst case scenario anyway, right? So what you should do, in my opinion, you should go ahead, confer with your lawyers, explain to them. My advice would be to file for extension of status within the United States, explain your circumstances, ask the government to forgive your being out of status for a few days. Or even if I don't even know if you are, but let's say you are. Explain to them that you have tourist status pending, and refer back to the discussion I had of when you have a case pending, they may not give you an H1, but it's worth asking for it. And the COVID situation are extraordinary circumstances beyond your control. So when you file the next H1, try to get status within the United States. If they don't, you have to go for consular processing anyway. Why give up without a fight? Okay. Go ahead with your questions now.
Yeah. So with the current employer, I mean, should I go with him or not? Because it's not a confirmed employment.
Look, I personally, first of all, I think it's still illegal for your employer to apply without a project. I don't think that's a good idea. And two, these guys, to my mind at least, they feel like sleazebags. They make you work without paying you for it. That's a sleazy move. Okay. I personally would not do business with anybody who's that sleazy. I won't. That's just me. None of our employers do it. Anybody who works with us, if they are that kind of a firm, a company, they will drop us and we will drop them. As soon as I find out they've been doing nonsense like this, I won't work with them. So in my view, you're better off waiting for a good employer, a decent employer, rather than working with these guys who are just trying to exploit people and break the law. Okay?
Got it.
Good luck to you.
Yeah, thank you.
You're welcome. Pennsylvania, I see you. Go ahead, Pennsylvania.
Yeah, so I think just a question, kind of a follow-up to this, that he asked about the B1, B2. So I was just wondering, in case I have an employer A who has worked for me part time, and I think we discussed about it last time very well, so I understand that it's allowed. The 60th day is August 2nd. So they are ready to go ahead because they have an offer for me. They can go ahead and file my LCA and I-129 petition by August 2nd. So with that receipt in hand, of course, because it's a part-time employment, I'm obviously going ahead and in the interview process for full-time employment. So if a company, employer B offers me full-time, let's say post August 2nd, and by this time, this petition is not going to be approved because, they probably don't want to do premium processing. So if that happens and the company B applies for my I-129 petition after August 2nd, would it be safe that this employer A withdraws the petition and I tell them I don't want to work for you anymore?
No, that's the exact issue we are testing in the court right now. So that's exactly what happened in the other case, where the second H-1B was applied past the life of the first H1, which is going to be your case. Okay, the second H1 was applied past the life of the first H1. Okay, in your case, your employer is filing an H1B within 60 days, which is the life of your first H1. The third employer, the second employer has filed the H1 within the 60 days. The third employer is filing it past the 60 days. So if the previous employer withdraws, then you're no longer covered by that, what is called a bridge petition. Your bridge has fallen down. Okay.
Okay. So the second employer, which is offering me the part time, should basically still go ahead and get the approval and employ me then?
They should definitely get the approval. If they have the approval, the second case on the bridge would be approvable without you actually joining, in my opinion. It's a little complicated. We may not have all the time we need to discuss every issue here, but be aware of the issues. Be aware that there has to be a bridge. How far does that bridge have to go? I am arguing that the bridge is complete when the first case is even pending. It doesn't have to be approved because the regulation says the bridge falls if the case is denied. It doesn't say the bridge falls if it is pending.
Right.
Okay. So discuss it with your lawyers. And of course, if we are able to back the government down, they don't fight us on this. If they settle the case, I will let the community know. Then you know that the government probably will give up on this issue. And I think this is a good issue for them not to fight because their regulation is very clear about it. So in your case, discuss it with your lawyers. Keep an eye out for our social media. I usually don't put our litigations on the social media simply because I don't want the government to feel any kind of pressure just to put up a fight because they don't want to look like fools. And they don't. They are pretty smart about what they do. I want to be very clear about that I have all the respect for the assistant U.S. attorneys who are carrying the brief for the government. They're very smart people, very hardworking people, but they sometimes don't have a case. If there is no case to fight, why would they fight it? So I'm hoping that that's how it comes up. So keep an eye, just come back to the conference call, post a question. I will let you know if the government backs off on that case. We should know within the next 3-4 weeks.
Okay, I see. So for now, what I was trying to understand is the part-time employer, is it fine that if, let's say, he puts the start date for me as August 1st, which is a day before my 60-day period, right?
Yes.
And do I have to start working for him? I know that there is
You do not. You do not have to start working for him. You have the option but not the obligation to start working.
Okay, that's pretty clear enough. So I don't have to start working from August 1st. I can always wait until the approval.
Yes, and not only that. The law says if you are in the United States, the employer has to employ you within 60 days of when the approval comes or the date you tell them I'm ready to work, whichever is earlier. So when the approval comes, you call them the next day and say, I'm ready to work. They have to start paying you right that moment. If you call them and say, I'll be joining you in 45 days, that's okay. They don't have to pay you.
Okay. So it is safe that I just wait until I get the approval for that one. That kind of gives me even breathing time, and that's legal, right? Because
Yes, sir.
I'm getting the breathing time
Yes,
by
sir. Yes, sir.
legally being here in the country, right?
Absolutely. Absolutely. And by the way,
of course, like you said, the full-time employer for the future will obviously probably not get the I-94 endorsement, and I have to leave and re-enter. That's fine with me.
well,
right?
but
Because I
you,
have
no,
my
no, no,
full
no,
staff.
no, no. Don't be in such a hurry, because if you leave, you can't come back till December because of that idiot's proclamation.
Right. But if I have an H-1B stamped already till August 2022, visa stamp.
Then you're okay. Then you're okay. I take that back. If your stamp is still good, then you just travel to Mexico and come back, or Canada and come back.
Yeah, or Canada, because I have a Canadian PR, so you know.
Oh,
better, right?
you are in a great situation then. You're fine.
Yeah.
Okay.
Yeah, so I think the safe option is I make the part-time employer wait, hey, that I'm not obligated to start working until the approval. And in the meantime, I go ahead and see I'm already in the interview process with the full-time employer. If he approves me, they let them apply and let them get the approval, and then I can withdraw the petition, right?
Yeah, I would argue for getting status, like I said, because the bridge has not collapsed until the case is denied. So I would definitely file the second case, premium processing. And by the way, it has been always my interpretation that while the employer is required to pay for the H1 expenses, premium processing can be paid by the employee if it is being done for the convenience of the employee, not the employer.
Correct.
Okay. So
I get you. And that's why the first one that I'm doing as a part-time, I will just not do the premium processing because I'm not in a rush to start.
Exactly. I don't see any problem with that.
So that will be still legal. Okay, so before the August 2nd, as long as the part-time employee puts in my petition, gets the receipt, I'm good to stay here. I'll tell them I'll join them only after I get the approval.
Yes.
If they want to do premium processing, they can go ahead and do it.
Absolutely.
Right?
Absolutely.
And then in the meantime, I get my full-time, and then, like you said, go ahead with the full-time, get the approval for full-time, and then withdraw the part-time.
Absolutely. That is the safest thing to do.
Fair enough. So that's pretty clear. Thank you.
Good luck, sir.
Yeah, thanks.
Okay. So the next one is also a frequently asked question about STEM OPT extensions for third party. Oh, this should be party, not part. Third party site placements. I'll correct that. So I have always maintained, I disagreed with my fellow lawyers when the government gave an interpretation that seemed to relax the availability of third-party site placements for the STEM 2-year extension, STEM OPT extension. I think that's not allowed. In my view, you can only do 2-year extensions for in-house work. Now, it is a possibility that if the employer has a team working on the end client site and you are a part of the team being supervised by a project manager or somebody senior of your employer, then STEM OPT could be possible for third party sites. But normally they have to be able to supervise you directly and not through phone calls or through Skype interviews or Zoom, what have you. That is not going to help. So in the first place, third party site placement should not go for STEM OPT extension. I think it's illegal. So should you apply for this and deal with an RFE? I don't think you should. In my view, this is, well, let me put it this way. It's not approvable. I don't know if I would call it illegal if the government is fully aware and they still approve your case. I wouldn't call it illegal. But I certainly think it is not approvable. I don't read the law like that. Okay. *5 if you have a follow-up question. *5. The only thing I can think of, the exception what I told you, is if there's a whole team of people or if you have your own project manager associated with your employer, not with the end client. I would say in that case, arguably, your STEM OPT extension is approvable. Okay. We don't have any follow-up questions on this. Okay, I'm done with the frequently asked questions. We had a bunch of them today. Let's go back to the, oh, there is a question. 1 second. This is area code 919. 919, where are you calling from?
From North Carolina.
Yes, sir. Go ahead.
Yeah, so that was my question. I was just wondering, so I accidentally disconnected just before you
No worries.
finished the last.
Yeah, what I said was third-party site placements are not acceptable for STEM OPT extension, in my opinion, unless your employer has their own project manager on premises at the end client site, and you report to him or her.
So right now I am looking for other employment opportunities, but I have to apply for the extension by August 20th. So is it possible for me to apply using this like this third party thing and then switch over to something just to give me more time?
I don't think so, Arvind. I really don't.
Okay.
Okay.
Like I can't even send in the application.
Yeah, I think you should look for a position that is in-house.
Okay. No, it's mainly for like getting some more time in case I don't find.
Yeah, I personally don't think that would help, because if the government considers the initial filing to be non-approvable, they could reject any other filings after that. Okay, so I think it's a dangerous path to follow. I haven't researched all the issues associated with it, but just knowing the way this process works and the government works, my shooting from the hip guess would be it's a bad idea to even file this application.
Do I have any other options in this case, or just try and find something else?
No, just try to find something in-house. Now remember, even STEM OPT can be for 20 hours. It doesn't have to be a full-time job. I think that's how it is. So just see if you can find a 20-hour job instead of a full-time job.
Okay.
Okay?
And can it be a temporary job, but for an employer?
Well, these jobs are supposed to be by nature temporary because you're on a temporary visa.
Okay.
So if it is for 3 months or 6 months or 8 months, that's okay.
Okay. I'll go ahead.
Okay.
Okay. Thank you.
You're welcome. Good luck. Okay. And I think we are done with these. Let's go back to our non-frequently asked questions. I think I only have like 4 or 5 of those, maybe more. Let's see. Here is the one from Vinay. Yes, Vinay, I'm doing fine. Thank you so much. My wife and our first kid are on H-1B, recently blessed with our second kid. They are in India. So my wife and first kid have H-4 visa, but the second kid doesn't. So isn't that weird? What are the options to get an H-4 visa? Because of the blockage for December 31st. Look, if you were a rich man, I would file a lawsuit for you. I think it is extremely ridiculous to apply the H-4 ban to a child who's not going to come here and work and compete with the US workforce. That's a ridiculous ban for this situation. Okay, so filing a lawsuit is definitely an option. It'll set you back a few $1,000s. I don't know if you would win, but you can try. You can also take this case to the press, make it public, make us think about it. You can also reach out to your congressman's office, see if they can assist. In my view, government should make an exception in these types of cases and issue an H-4 stamping. I looked at the proclamation. It was a little unclear. It's very poorly worded. Many parts of it are written like it's a 8th grade child without thinking about the long-term ramifications of what they are writing. Very poorly written proclamation. It wasn't clear to me. For example, one of the ideas that came to my mind, if in a case like this, what if we apply for humanitarian parole? Can we do that? And my answer to that is You could try. How does that work? Well, when a visa is not available, you can apply directly to the USCIS. Actually, go to the USCIS website and search for humanitarian parole. You could try getting a humanitarian parole for the child. See if that works. Okay? But if you get that, make sure you coordinate with CBP as well. And again, I would run this by our congressman's office, call them up, say that I need some information. If I get a humanitarian parole, would the CBP let me have my child enter the United States? So that's what I would recommend. If you don't want to put the money into a lawsuit, go ahead and try to do it through a congressman's office. *5 if you have a follow-up question. *5. Okay. Next question is from Prasad Gupta. I got laid off, termination date set in August. I have an I-485 pending, downgraded from EB2 to EB3. As per the visa bulletin, EB2 date is just 10 days away and EB3 is 40 plus day. What if my priority date is reached for EB2? You will need to inform the government and request specifically that your case be converted back to an EB2. Can this only be filed by employer attorney, or can I individually request this? Good question. I think you should get your employer involved at least. You don't need your lawyer, but I think you need your employer. What if the priority date is reached for EB3 in August, September? What options do I have if an RFE is received? You'll have to procure a job offer in a same or similar job. You'll have 87 days. Okay. Do you have to get a job that matches the prevailing wage? No, you could get a lower paying job as long as the job description is same or similar. But if the wage is cut down 50%, sometimes quantity overshadows the quality. One wonders, if you are taking a 50% pay cut, are you not changing the job? So if there is a 10-20% pay cut, but the jobs are substantially similar, I think you'll be okay. *5 if you have a follow-up question. *5. All right. Next non-frequently asked question is from Sanjeev Kale. Oh, Sanjeev ji, you're very welcome. Green card for my parents. They left in January 2020. So what happens if they've been gone a year or more? There is no guidance that specifically addresses this issue. But I think in cases like these where they end up staying more than a year and they have a susceptible condition making them more likely to fall victim to the virus infection, I think the government should be able to reinstate their green card through what is called returning resident permit process. So far there is no definitive guidance. I can't tell you anything more than that. But also remember, if for some reason the green card is taken away, you can always apply for it again. There's nothing in law that stops you from reapplying for the green card. *5 if you have a follow-up question. *5. Okay. Geeta is a registered nurse in H4 status. I-94 is expiring next year. Employer is going to do my green card. And from your name, I'm assuming you're a Nepalese-born person from Nepal. Both my I-140 and 45 are still pending. Okay, I found an employer who sponsored me. 45 is pending. I got an EAD. Is it advisable to work on EAD while I-140 is still pending? Why not? Why not? I don't see any reason why not. I got an RFE on I-140. Well, it depends upon the seriousness of the I-140. But definitely, if you start using your EAD, your H4 is lost. But if you have an H4 visa stamp on your passport, you can travel outside USA like Canada or Mexico if it's possible and come back using the H4 visa. You will not be covered by the proclamation because you have a pre-existing visa on your passport. But if you do not have a visa on your passport, then I think using an EAD may not be a good idea. *5 if you have a follow-up question. Yeah, you don't automatically fall back to H4 status. So if you use EAD, you've lost the H4. You have to convert back by leaving and coming back. Okay. So next question, Reddy. Oh, there's a follow-up. North Carolina, go ahead.
Hi, sorry, just about the really quick question about the OP teaching again. Does the start date of the job have to be at the last day of my current EAD?
I don't know the answer to that question. I believe so.
Okay.
Okay. Good luck.
Thank you.
Next question is, Reddy said, lost H4 EAD card, which was good till June 2022, applied for a new one, got the receipt. Employers asking for an EAD card. Well, first of all, there's something called document discrimination. Employers should know about that. If a document is acceptable, the employer shouldn't ask for any other specific document. There's something called the receipt rule. The receipt rule. The receipt rule says, if you have applied for a replacement card, not an extension, but a replacement for a lost EAD, you can start working with the receipt, and if in this case you have a soft copy of the previous approval. Okay, so do some research on the receipt rule. Show it to the employer. Oh, you have that already. You've looked at it. Okay. I don't know about the validity for 90 days. I haven't looked at it. So obviously you have done more homework than I have on this case. I didn't know that there was a 90-day limit on the receipt rule. I would have looked it up. But if there is a 90-day limit, obviously you have to stop working. And if you continue to work after that, and it's a violation of the regulations, that would be working without authorization. That would be a very bad idea. *5 if you have a follow-up question ready. Okay. Member 24, after filing the H-1B amendment to USCIS due to change of location, can I start working from the new location immediately from the day it is filed, or wait till the receipt? In my view, you can start working from the date the H-1 petition is delivered. But it is better to get the receipt, especially if you file premium processing. It's a good idea because that way the employer can complete the I-9. I've had employers complete the I-9 with a FedEx delivery. Okay, so the way I read the law, you can start working upon physical delivery of the H-1B paperwork. *5 if you have a follow-up question on this. *5. Okay. Oh, there is a follow-up question from area code 510. 510, where are you calling from?
From California, Fremont.
Yes,
Rajiv.
sir. Go ahead. What is your
Sorry,
question?
I was trying to unmute for the previous question. It was that lost H4 EAD one.
Oh, yeah, go ahead.
So the employer is looking to file that I-9 form, which he needs a copy for H4 EAD. And since it's been the notice on the USCIS website or receipt, it says 90 days acceptable, but it doesn't specifically say for the lost ones. It only says for new ones or something like that.
No.
That's where I still got.
I'm not sure what we are talking about here, but I know for sure that there is something called the receipt rule. I don't have time to research it for you. You can have your lawyers take a look at it, or the employer's lawyers take a look at it, but I think it should not be a problem. And there is a specific way of preparing an I-9 for these cases that should be available on the I-9 frequently asked questions on the ICE website. Okay?
Okay.
Good luck.
Okay. Thank you, Raj.
Oh, you're welcome. Okay. So when I file the amendment, can I start working from the day it is filed? Same answer. In my view, it's not the receipt, it's the date of filing that counts. *5 if you have a follow-up question on this, on the amendment. Okay. Oh, there is one. All right, let's see. This is from area code 224. 224, where are you calling from?
Hello, I'm calling from Chicago.
Yes, ma'am. Go ahead.
Okay. Thank you for answering that question. So, I can also change my location, like move to the new amended job location, right?
Absolutely. Absolutely. Make sure you file your AR11 if you change residences.
Okay. What is that? AR11?
Yeah, AR11. Under the law, until you get citizenship, whether you are on a tourist visa, on a H1, F1, or even green card, every time you move residences, within 10 days you have to file Form AR11. It can be done online. It takes 5 minutes.
Okay, perfect. Thank you so much.
You're welcome. Okay. Good luck.
Thank you.
Okay. So now, let's see, we did this one. This one is, I'm on H1B, I-140 is approved, priority date is 2014. Company might get closed. What will happen to my I-140? Can I apply for EAD under special circumstances? Well, there is such a thing as EAD under compelling circumstances, EAD. And if you go to, I'll post something on LinkedIn, okay, because I was meaning to post that. I've been asked the question about compelling circumstances, EAD, a lot. So I'll post the infographic on LinkedIn. You can take a look at it. If you fall under those circumstances, you can certainly try. But one thing that makes me uncomfortable about companies closing is, and I could be wrong, but if I remember correctly, there's actually a regulation which allows the government to go back and revoke your I-140 if the company stops doing business. Will you be able to carry your priority date? I think so. Will you have the right to extend your H1 for beyond 6 years? I don't know the answer to that question. I'll really have to research the law. I don't remember off the top of my head, but be aware of these two issues. Okay, so compelling circumstances EAD is not uniformly available, but it is available if there are some unique circumstances in your case and the I-140 is approved. *5 if you have a follow-up question on this, *5. Okay. Son is aging out of H4 status, wants to convert to F1. If we have filed 485, what happens? In these cases, so far, it has been my experience that the government has been tolerant and they've been approving F1 statuses even where 485 was pending or about to be applied or named in the I-140. So far they've been doing it, but of course, if the government were to take a classic view, they could refuse this. They could say, no, sorry, we are not going to approve your F1 because you have immigrant intention. But they've not been creating that problem for aging out kids of H1, L1 type of situations. *5 if you have a follow-up question, *5. Okay. Anybody has any question? I know we are out of time, but I don't mind spending a couple of minutes extra. *5 if you have any question whatsoever. Meaning of life. What should I do for a living? Okay, only one. Wow, that's perfect. Okay, let's go ahead and answer your question. Area code 805. Where are you calling from?
Hi, Rajiv. I'm calling from Chicago.
Okay, go ahead.
Yeah, so my H1 is expiring in October, so my employer has filed for both H1 and H4 and H4 EAD for my wife. So in this current coronavirus situation, do you know if the H4 EAD is going through? I heard that as per the new requirement, they need to go through some biometrics.
Right.
What are the chances that? Yeah.
Right. They have not restored the biometrics yet. So I don't know how long they are going to be at it. Going by the noises Trump has been making, they do want to reopen things, but I'm sorry, I don't have any special information beyond what is publicly available.
Okay. All right.
Good luck to you, sir. Guys, as always, I am thrilled to be talking to all of you, and thank you all for being here. I'll see you again in 2 weeks. Stay safe, guys, and keep those masks on. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.